Hey good people, have you heard about Tickle V Giggle? It may sound like a trivial board game, but it's actually the most important court case in a decade. The legal teams are preparing right now, and it's set to go to the Australian Federal Court in April 2024. And this case will actually determine whether biological men who claim to be women can use the women's bathroom, compete in women's sports, and force you to call them a woman when you don't believe that they are. 3 years ago, Sall Grover had an idea. She had just returned from Hollywood, where she had experienced Hollywood, and she wanted to create an online, female only haven in a vast sea of social media. She was going to create an app, and we can basically think of it as female only Twitter. There's a bit more to it, but we'll just leave it at that. Now, how do you make it female only and keep out the creeps who would obviously want to infiltrate and troll women? When you created your profile, you had to take a selfie, and an AI would use that selfie to determine whether you're a male or a female. Turns out you can actually make this determination at a glance. This capability has been around for a long time, so she just purchased the software and incorporated it into her app. Now, nothing is perfect, which is why they decided to set it at 94% accurate. Better to let a few men slip through and delete their accounts later than to reject one woman. And this is where the troubles begin. A biological male who dresses as a woman, self-named as Roxanne Tickle, got onto the app and then had his account deleted. While he was able to slip one past the AI, he wasn't able to pull the wool over the eyes of the other female users, and they reported him to the developers who deleted his account. It was standard protocol. Somehow, he got Sall Grover's phone number, and he called and texted her to complain. And when she ignored his complaints, he decided to take it further. 2 months later, in January 2022, Sall Grover received a complaint from the Australian Human Rights Commission citing gender identity discrimination. And this is where things get really interesting and really important. The AHRC is funded by, but independent of, the Australian government. They can do things like request you come to conciliation in order to resolve a dispute outside of court. But they were treating Sall like she was already guilty without even having spoken to her. Knowing that she would never agree to their terms of gender re-education and allowing men onto her female-only app, as well as being heavily pregnant, Sall Grover said, "Screw you, the truth is on my side." Roxanne Tickle then filed for federal court in December 2022. Now, while Roxanne Tickle has received a grant of $50,000, as well as his lawyers working pro bono, Sall Grover needs to raise $500,000 just to be able to call a man a man. And it doesn't even matter who wins, because whoever loses is going to appeal to the High Court, where Sall will need $1 million to fund her legal defense. Now you might be thinking, oh, here we go, it's the old fundraising thing to get this chick out of a bind. And you're right, but it's so much more than that. This court case will eventually be as famous as Roe v. Wade. If Sall Grover wins her constitutional challenge, then all of Australia, and even beyond Australia, will be affected by this. Let me explain. This case is a constitutional challenge. A constitutional challenge challenges the validity of a law, not whether a law has been broken. And Commonwealth laws derive their power from Section 51 of the Constitution. Section 51 of the Constitution enumerates the legislative powers to the states at the time of federation. Each subsection provides a topic under which the Parliament is empowered to make laws. The external affairs power supports laws with respect to matters physically external to Australia and laws affecting Australia's relations with other nations. An example would be the Tobacco Plain Packaging Act, as it relates to Australia's international obligations to the World Health Organization. It's one way that Australia's laws are considered legitimate. Federal Parliament can only make laws as based on the heads of power and the external affairs power that allows the Australian government to sign international treaties and conventions on behalf of the Australian people. This process dictates what the law will be, as they have to exist in relation to international law. The Tickle v Giggle case is gender identity versus sex. It's the first time there's been a case in Australia, and to an extent the world, in the sense that it directly deals with the conflict between gender identity and sex and its relation to CEDAW. What's CEDAW? In 1979, CEDAW was adopted by the United Nations. CEDAW stands for the Convention on the Elimination of All Forms of Discrimination Against Women. Not a very accurate acronym, but COTOFADA doesn't roll off the tongue as well, so CEDAW it is. It's basically a Bill of Rights for women. In 1984, after Australia became a signatory of CEDAW, we had to give effect to it. So we created and passed the Sexual Discrimination Act. The SDA gets its legislative power from the fact that it enlivens CEDAW. So the SDA was created to give effect to CEDAW. CEDAW was signed onto by the Australian government. The Australian government was authorised to do that under the External Affairs power. The External Affairs power makes the SDA legitimate because it exists in relation to the international treaty CEDAW. Now here's the twist. In 2013, there was an amendment to the SDA which replaced sex with gender. This is the 2010 version of the SDA, and right here in objects it says to eliminate, so far as possible, discrimination against persons on the ground of sex. And here is the amended 2013 and current version, and it says to eliminate, so far as is possible, discrimination against persons on the ground of sex, sexual orientation, and gender identity. And if we scroll further down on the 2013 version, we get to the definition of gender identity, which is gender identity means the gender-related identity, appearance, or mannerisms, or other gender-related characteristics of a person, whether by way of medical intervention or not, with or without regard to the person's designated sex at birth. Now, I'm just going to make a critique of usable definitions. First of all, with or without regard to the person's designated sex at birth. Right, well, if sex is irrelevant to defining gender identity, then leave it out of the definition. That doesn't help us define what gender identity is, whether by way of medical intervention or not. Again, if medical intervention doesn't help us define the word, then it's irrelevant. You could have just said nothing. Don't tell me what it isn't, tell me what it is. Now, we're trying to define gender identity, and you can't use the word in the definition of the word because we don't know what the word means. So, we take out gender identity from the definition and we're left with gender identity is the related appearance or mannerisms or other characteristics of a person. That's not really a definition. I haven't really defined anything or said anything of useful substance. Compare that to the 2010 version of the SDA, where we had clear definitions of what a man and a woman were. Those definitions were removed in the 2013 amendment. And who's responsible for taking out the definition of a woman in the SDA? Australia's first female Prime Minister. Oh, the irony. Now, how does this all tie together? Well, the SDA is based on CEDAW. It is only considered legitimate because it enlivens CEDAW. And back in 1979, when CEDAW was created, the concept of gender identity hadn't even been imagined yet. 40 years ago, if someone had said, what if a man pretending to be a woman gets excluded from an online app? We'd have all been like, well, that's a strange question. What's an app? There was a clear understanding of what man and woman meant. And if the SDA has been altered and no longer reflects the original intent of the treaty that was ratified by 189 countries, then that section of the SDA is not legitimate. And that is the argument that Sall Grover and her attorneys are going to have to make. Pretty interesting, right? Now, news.com.au did a poll in September with 50,000 people where they asked the question, should transgender athletes be allowed to compete in women's sport? 82% of respondents said no. And interestingly, 4.2% of people said trans women are women, which is something we've all heard before. And I've always thought, if you really believe that trans women are women, wouldn't the correct statement be women are women? To which we would all go, yeah, obviously. But the fact that you had to put the word trans in front of women shows me that you know that there is a difference between trans women and women. Sall Grover expresses that she doesn't mind what choices people make in their personal lives, and she's indifferent as to whether someone identifies as transgender, which I think most live and let live people agree with. You know, if it neither breaks my leg nor picks my pocket, what business is it of mine? She emphasizes her concern about being compelled to endorse beliefs that she doesn't personally hold, a sentiment which I think everyone understands. Attempting to enforce adherence to this ideology feels akin to compelling an individual to pray to a deity that they don't believe in. If you're unsure about this issue, then feel free to reach out in the comments. If the information I've provided has been valuable, consider subscribing. If you want to support the legal fund of Tickle, then check the links in the description. If you want to contribute to Sall Grover's legal fund, then the links are also in the description. This court case extends beyond Sall Grover, and it affects all Australian men and women. If you think you could find yourself in a situation where you want the legal support to express your boundaries, such as not allowing someone into your daughter's change room or refusing to use certain pronouns, you will be able to reference the Tickle V Giggle case, and that will be the end of that. People across the world have been waiting for someone to challenge what they perceive as confusing doublethink. And now there's a person taking a stand. Supporting Sall Grover means supporting the potential for legal clarity so that you never have to go through the legal battle yourself. Sall Grover is taking it on for you. Remember, you were born free.